Welcome to the Lead with Excellence podcast. My name is Melissa Jones. Today we have Paige Hulse with us. She is an intellectual property attorney, business strategist, and serial entrepreneur. Since forming her own law firm in 2017, she has built 5 additional companies. As an entrepreneur herself, she finds the deepest fulfillment in practicing law as an advocate for fellow entrepreneurs. In addition to assisting clients with the creation and protection of their intellectual property, she focuses a majority of her work as an outside general counsel. In this role, she assists businesses in implementing intellectual property strategies for legacy building succession plans. Welcome, Paige.
Thank you so much. I'm really excited to be here today.
Well, that's great. I am excited to talk to you. You came with high recommendations and the wealth of knowledge. I really am excited to dive right in. So we'll start with succession planning. Depending on where you're at in business, this may not even be on your radar, but if maybe you have been in business for 20, 25 years and you're looking to bring on a partner or sell the business, this a lot of times comes into then the conversation and your planning. But sometimes you haven't put the pieces in place to make it easier for succession planning. So I'm curious, Paige, then what role does IP play in succession planning, whether bringing on a partner or selling the business?
Yeah, and even backing up, Melissa, for a second from there, I want to define, succession planning is I'm going to say intentionally vague word in the legal world. And so I want to kind of simplify what exactly we are talking about here so that everyone listening has context, because again, this can be something that people dedicate their entire career to, just this one topic alone. So when I talk about succession planning as an entrepreneur, and obviously from a legal perspective as well, I'm talking about how we can ensure, as leaders of our companies, no matter what phase of business we are at, how we can ensure that this company extends beyond ourselves and how it can endure without us. So looking at a lawyer's job is obviously to look, hopefully at least 3 steps, if not more, into the future, and ensuring that our company can survive the inevitable shifts that will occur within business. So what I mean by that is looking at, just to your point, exactly how best practices for bringing on a partner, exit strategies, how to prepare for mergers and acquisitions, etc. So again, that's just a very brief overview of what I'm looking at. And to actually now answer your question, the role of intellectual property when looking at business succession planning is monumental, because in our everyday lives as business owners, we are creating intellectual property whether we know it or not. And this can be, again, just to kind of bring it back a little bit. When I say intellectual property, we're talking about copyrights, patents, and trademarks. Copyrights cover tangible works of authorship, so that's what we're typically creating day to day. Trademarks cover logos, slogans, and business names or brand identifiers, and patents cover inventions. So in the business, in the course of our business as entrepreneurs, we are inherently creating these assets every day and building the bottom line value of our companies through that creation. I specifically use the word assets because these are all elements, or these are assets that we can license out, that we can monetize, that we can sell, that will be at some point in the future when, again, looking at this from a business succession standpoint, these are items that must be defined and that will be transferred at some point in time. So determining, first of all, that whenever I'm talking to any client about this, first thing that we have to do is, of course, identify what we've created and then what steps we've taken to ensure that we actually own that creation. That's a whole lot of like word salad I just threw at you. So I'll stop for a second and see if you have any questions about that.
No, all of it makes sense. And when you're saying that assets are identified and then ownership as well, is that just part of due diligence? and like your research of making sure that it's an asset for that business?
That's a good question. So I'm actually one of my favorite. I'm actually talking about that more from just a business owner perspective. And I say that because one of my favorite things about the way I get to practice law is I'm an entrepreneur working along, like I'm in my client's shoes.
Right.
And it becomes a matter of training, I would say, like training your business eye to identify what you're creating that can be considered an asset. So for example, a lot of clients that I work with don't realize that they should that they've created copyrighted works such as a course or something along those lines, and something tangible. That's usually the first one that comes up. And they don't realize that in order to stop infringement and in order for that to be an asset that can be transferred or sold in the future, they have to have that registration in place before the infringement actually occurs. So again, as business owners, no matter what phase of business you're at, just familiarizing yourself with this concept of intellectual property, being able to identify what you're creating in your day-to-day business that falls within the parameters of intellectual property, and then looking ahead from a business succession standpoint, determining what assets or which pieces of that intellectual property you would want to be able to transfer out in the future as a sellable asset, or again, something that you can license out, different ways that we can generate revenue for the company.
You brought up a good point, which I'd like you to expand on, is what additional assets can be included in intellectual property. You mentioned courses. That's common, and I think we'll continue to see that because it's an easy way for recurring revenue.
Mm-hmm.
But what else does that include? Like, is that workshops? Is that memberships? Is that if you have a custom process to your business and the way that you conduct like your client work?
Yeah, those are great questions. So yes, everything that you just mentioned, processes and methodologies are very tricky. I'm going to kind of put that to the side because that takes a more complex intellectual property approach. But for example, I have a lot of clients right now that are building, like you said, memberships or building apps right now. That's a big thing that's happening right now. And in order for those clients to be able to take action against infringement, but more importantly than that, if they build an app that takes off like wildfire, and they have inquiries from other business, and this is happening with a client right now. She built an app, it's taking off like wildfire, and she's having inquiries are coming in from around the country asking to license out that intellectual property so that they can host that app on their own platform, et cetera. It's a little bit nuanced, but again, keeping this high level. She has to have that registration in place to ensure that she has the capability to take advantage of those monetization opportunities that are available. And later on, if and when she does want to sell that company, and I would love to talk about how I view splitting off different arms of companies and selling different areas of a company. But she has to have the registration in place in order to take advantage of that and to set herself up now to be in a position later on to take advantage of those opportunities as they arise.
Does that also help if they want to bring investors on board, that it protects it when you have that discovery conversation and a lot of proprietary information is disclosed?
Yeah. So I was actually at a few months ago, I was actually at a family office investor meeting, which was interesting, very interesting, literal boots on the ground perspective with that. Let me break this part down into the most simplistic terms possible. From an investor's perspective, and anybody with any sort of legal eye, or anybody who has an outside counsel coming in and providing, legal assistance before investing in a company, any unsecured, i.e. unregistered piece of intellectual property is a huge red flag in terms of liability that invites in the door of the company. So if I'm representing an investor, and let's use the client example that has the app. Let's say that she hasn't copyrighted that app, or she has not registered the trademarks associated with the app, et cetera. I know that for every brand identifier, so the name, logo, slogan, and the actual tangible authorship, the app itself, if she doesn't have the registration for that, she's a sitting duck for somebody to come along, steal that intellectual property, or even potentially more dangerous, a sitting duck for somebody to come along and say what she's created is too similar to what they've already created and completely eliminate her ability to actually continue with that business. So it lowers unsecured or unregistered intellectual property, lowers the value of a company significantly.
That makes sense.
Okay.
So we'll go into the selling arms of the business.
Mm-hmm.
Like there's so many tangents I think that we can go on, but since you mentioned that recently, we can go there.
I think that's important this is something that I want people who are even 6 months into business to be aware of. Again, we want to strategize now so that we can implement, and who knows what direction entrepreneurship's going to take us. That's one of the things that's so aggravating, but so thrilling about it at the same time. So when I'm building my companies and I'm looking at when, why, and how I splice them out or create separate entities from that first, we'll say umbrella company, even though that's not the correct legal term, but I think it makes sense. I'm looking at that from a two-pronged, I take a two-pronged approach. I look at that from a liability perspective and from a tax or financial perspective. And then looking ahead also at the opportunity to sell. So for example, let's take what I see most commonly, which is somebody who starts selling, who starts a business coaching or a service provider of some sort. And then we can use even the example of a graphic designer who then creates templates or creates online courses. They branch into an education side of the company. When I'm looking at that type of scenario, which again is something I see every single day, I'm looking at the future opportunity for that, again, that two-prong approach. I'm looking at what liability does the education arm of the company bring into the service provider arm of the company. What tax benefits would be available if we split those two entities, if we split that entity into two and elected to be taxed as S corporations. And I'm not a tax attorney, so I then punt that question to my accountant that I work with on those deals. But it's worth mentioning. And then the third factor I'm looking at, and that is if somebody were to approach her tomorrow to purchase that template shop or that education side of the company, how is she best positioned to take advantage of that? Whether or not she wants to, we want her to have the ability to make the choice. That's the important part. A lot of entrepreneurs don't look at building a business from this perspective, and then they're faced with this type of opportunities and they find themselves on their heels. And you never want to be the retroactive person scrambling in a scenario like that.
I agree, because business is more playing chess than anything.
Exactly.
And I mean, you're one of the chess masters because that's your expertise of thinking 3 steps ahead. But I think a lot of people take that for granted and they're just operating in their craft and having fun with it and not realizing all of the implications and the ripple effect of everything that they do.
And sorry, I didn't mean.
That's all right.
Yeah.
The example that you just gave, I think even a podcast is one of those things. And I say that because just reflecting on like a lot of the different business models, if someone were then to have their podcast get picked up by Dear Media, and then what's that financial situation look like? And maybe you're not able to properly come to the table because you haven't, like you said, kept it separate. You don't have the financial numbers specifically for that arm.
That's exactly right. And thinking like this and thinking with that futuristic mindset, I know comes easier to some than others. And I also know that obviously as being an entrepreneur, like we can get, it's hard. And so just, we can get into that day to day, just churning out the work and keeping the company alive type of feeling. But I want to challenge everybody listening that viewing business in this way, keep anything that you're building thinking, how will this business be conducted 3 years from now? That's a muscle that can be cultivated. That's not something that's not a gift. I think some people are born with that gift more than others, of course, but that's not, there's no barrier to entry to that skill set. That's just something that you train into yourself over time. And so, yeah, and that's a misconception that I want to dispel for a lot of people, a conversation that I have with a lot of people, because and of course I have, I have to talk with a certain like gag order in terms of some of the things I've seen, but you would be shocked at some of the clients that I have that have built businesses that just exploded or even didn't, but they were like right on the edge of that explosion, and an outside investor or an outside a purchaser, we'll say, recognized that they were at that precipice. And the clients, it's in some of those instances, clients who had thought ahead and who were ready to think about, where's this company going to be 3 years from now, they were ready to just take action immediately when faced with those types of opportunities. Clients who didn't recognize that they were at that precipice point yet, but that more experienced eye who wanted to come in and purchase them did realize that. They didn't set themselves up to be in the best negotiating position. And again, it's a choice, and that's something that can be fixed later on if you're working with the right team. But I want everybody to recognize that the company that you're creating right now, at some point in time, you will exit that company, no matter what. Like, no matter if you sell it, no matter if whatever, at some point, like 1,000 years from now, you're not going to be running the same agency. Like, it's just not going to happen.
Right.
So of course, one of the overused terms in the world of entrepreneurship is build a business to be sellable. And that is exactly right. But these are this conversation, these are the tangibles in terms of that back up that statement, and training your mindset to look 3 years down the road is step number one.
One of the things that you said made me think of collaborations, and how collaborations, if done naively, we'll say, can expose businesses in ways that they didn't anticipate. And what I'm thinking in that is specifically a business that is more savvy, and they'll want to do a collaboration because then it allows them to have access to the data and the business model, so they can see things behind the scene to see how well it works. And because they have access to that data, whatever the terms are, they might be able to then flip it for their own benefit. And I say this because I think a lot of times there are small businesses that have collaboration opportunities that come to them from larger companies, whether that's a Fortune 500 company or just maybe a tech company that's more savvy, and they get enamored with the idea and don't realize the risk or the things that they need to do to protect themselves.
Absolutely. So that when you started talking, I immediately thought of, again, two iterations of that fact pattern. Unfortunately, I have seen that happen quite a bit. And that's where I want anybody listening, and I think it's most of us, like at some point in time, it's, I don't like to speak in absolutes, but you're most likely, if not definitely, going to be faced with an opportunity to collaborate with somebody.
Yeah.
Even if somebody listening doesn't think that they will ever want to collaborate with somebody, at some point your company might grow, and you want to bring somebody in, and you want to pay them, you want to give them part of the equity of your company rather than an actual paycheck. Like, there are a lot of variations of how this can play out. But back to your point here. Anytime that somebody wants to enter into a collaboration like that, I tell those clients two things. First, I want them to make sure that they have their separate entity, because a separate LLC, because I don't want the person that they're or the company that they're collaborating with. I don't want any liability to bleed over between those two entities. The second thing that I have them look at, of course, is ensuring that they have secured all of that intellectual property like we've been talking about, because to your point, I don't want a bigger fish to come in under the guise of a collaboration and strip all of the IP from the small fish, go off, replicate it, and then squash the small fish later on. And that does happen, but it's avoidable as long as you hear this conversation, go look at your company, see what assets you have that you need to what intellectual property assets you have that you need to register. That's the simple step that you need to take just to make sure that you're not in that position. The second thing I thought of as you were talking about that is I see a lot of people collaborate in terms of, like two service providers who collaborate on an education or an education company or a template shop or some element related to their original industry. And I have the exact same argument. Unless somebody comes from corporate and has seen, or not even corporate, but unless somebody comes from a company and they've seen the legal side, I have the exact same argument with everybody every time. And it plays out the exact same way every time. But that is, it's great that you want to have a 50-50 partnership. That's a little bit dangerous. I would be careful about how, I wouldn't recommend it, but I understand why you want that. However, you have to create a separate entity. You don't literally have to, but in the strongest terms possible, I want you to create a separate entity that with that business partner, because in the eyes of the law, if you're calling yourselves business partners, but you have just created a course together, for example, just to test it out and see how it goes, the law literally imputes shared liability between you two. So whether you think that you've actually created a partnership or not, the law's already decided that. And you don't want your business partner to get squirrely and do who knows what.
Right.
And, the company, what I usually see is one party ends up carrying more of the workload than the other. Almost every single time I see
there's an operator and a visionary.
Exactly. And it's, I think that's just human nature, and that's a whole other conversation, but I see that every single time. And if those partnerships or joint ventures, whatever we want to call them, don't have a buy-sell agreement in place or an operating agreement in place, then you're in a position where it's usually the person who's doing the 80% of the lifting who has to have the tough conversation with the 20% lifter in that arrangement. And obviously the person doing 20% of the work but still getting 50% of the pay isn't going to want to change structure. I mean, it's just, I don't need to over explain that. Yeah.
You're not going to give up something that you already have that makes you comfortable.
Exactly.
No one goes to less money unless they're forced.
Exactly. And you can tell me to stop at any time. But the other thing I think of as well is you never know when something's unexpected is going to happen. I've had 10 major surgeries since I've started my business, and I knew about 8 of them the day that they happened. I didn't have any time to prep for 8 of them. So you literally never know what's going to happen, and you have to whatever you're creating with someone, you have to have that prenup per se in place. I kind of hate using that term, but you have to have that business prenup in place so that you can prepare for the unexpected. Because it may not be any fault of one of those partners or the other, but life happens. And sometimes somebody might need to kind of step back for a few weeks or, whatever the scenario may be.
What's continuity look like?
Exactly. And it's just as the leader of your company, you have to think that way, and you have to like, the one thing you need to be prepared for is chaos. That's what leadership is. Yeah. Yeah, exactly. Exactly.
I want to jump into processes and methodologies because I think that's an area that people take for granted. And so one of the questions that I have in regards to that is there's two parts. So the first part is how do they play a role in the succession planning and how are they having them documented a benefit to that process?
Mhm.
And then an additional question to that is I've noticed that some businesses believe that they have a defined process because they have an automated workflow.
Mhm.
And so my question for you, and maybe I'm jumping ahead, is that automation alone considered IP, or do they also need to then document each step of the automation to have a tangible asset?
You're asking a really good question and a really hard question, which I love. So I want to try to answer as straightforward as possible. But I literally had this conversation with 3 people yesterday, and I had 3 different answers for each of them. Because it is a bit case by case, of course, but the most simplistic answer is there is no intellectual property just point blank covers a process. Okay. So stripping this down, stripping the legalese out of this, when an intellectual property attorney such as myself has to go in and register the intellectual property, first I have to decide what type of intellectual property we're talking about. Is it an invention, an invention, meaning a patent? Usually not.
Right.
I've never actually seen anybody truly fall into that category. Is it a copyright? Usually.
Yeah.
Is there a trademark at play? Usually. So in order to, anytime somebody like myself has to file a trademark application, for example, I have to literally fill out we have to fall into a certain class, and I have to fill out the goods and services description in a definite way, showing that you are using a brand identifier in association with that description of the goods and services in commerce. So I'm going to set that statement to the side for a second. With a copyright, we have to file, they have certain types of copyright applications you can file, whether it be a motion picture or a literary work or whatever type of copyrighted material that is. That's where we have to be crafty, because there's no copyright application for methodology or process. So I have quite a few clients who who've created methodologies or processes that are truly novel and that we were able to secure protection for, that they've licensed out. And I have stories of people who make literally tens of thousands of dollars a month just licensing out their methodologies. In each of those cases, it took being highly strategic from an intellectual property perspective and ensuring that we license out, or excuse me, typically we register the trademark for the name of that process that you've created. And if I'm able to find, and this is where I have to be a little abstract, but if I'm able to find, for example, if you have a curriculum that goes alongside the methodology, we're able to copyright that tangible work, because again, we need a tangible work.
An asset.
Yeah, the difficult part with registering registering intellectual property for a methodology or a process is that by default it's intangible.
Mm-hmm.
And so I always challenge the client to how can we make it tangible?
Right.
Really challenge your creative thinking, whether that be a curriculum, whether that be creating a course that goes alongside the methodology, whatever. And that's where it's obviously very case by case, but something tangible, so that we've covered both the copyright aspects, all of the tangible aspects that we can, we've made them tangible. And then also the name itself, so that when somebody approaches you later on and wants to purchase that or license it, you're also in a better negotiating position, because now you have 2 pieces of IP that you can play with in terms of licensing and negotiating those deals, rather than just the one. Believe it or not, that's the most simplistic answer I can provide for that.
That's fine. So my mind then goes to if you make your processes and methodology internal training and make it a tangible asset for the business and then name it. I mean, you probably can't give me an answer on that now, but that would be like my thought process to move in that direction.
I would always recommend having always recommend having a name for it, so that you have that trademark protection. And then, yes, to your point, when you say making it internal, that's where I have a specific client I'm thinking of that I don't want to be too, I can't give details. She was able to create a training module and like course that went along with that methodology. And that's how we were able to secure the copyright element to it as well.
That makes sense.
Yeah.
So it's on social media, we see so many people share things from behind the scenes to feed the content machines.
Mm-hmm.
And so I'm curious, how does that impact the ability to designate something as proprietary information or the ability to assign value to IP?
That's a good question.
Well, even like, I think it's that thinking 3 steps ahead, like there's this pressure to share everything and anything. Mm-hmm. And I think discerning business owners know not to, mm-hmm. but then others may not know to. And then like, what's that all look like from your end?
That's a great question. And it's ironic timing that we're talking about this because I'm launching something in 6 weeks and I've accidentally been cryptic about it online just because I've been so busy that I literally haven't had time to say anything other than I'm working on something. But also I'm not sharing any of it, but I'm willing to give up that behind the scenes.
Right.
For a few reasons. One, when your note about what is considered proprietary, my mind immediately goes to the contractual side of that. So is there an NDA at play? Any sort of non-disclosure or non-circumvention agreement at play that puts a gag order on sharing how whatever the thing is being created, whether that be, again, let's just use the example of an app. Did you have your designer or your developer and your designer sign NDAs? You should have. When developing the app, you don't want them to be able to share sneak peeks of the building. They can maybe, they can share it later on as more of a like, here's what it looked like. Here's what you didn't see the last 6 months.
Right.
But they would be in breach of an NDA most likely if they shared. I can tell you if it were my company, they would be in breach of an NDA if they shared glimpses like that. In terms of actually giving up like trade secrets or actually damaging your intellectual property, so I'm not going to hit on the patent side of things. From a copyright or trademark perspective, I actually am not as worried. My consideration primarily lies with the contract side that we were just talking about with NDAs. I'm not as worried when I see people do that. I'm not as worried about them. Okay, here's why I'm not as worried about the intellectual property side. Well, the minute I file a trademark application or a copyright application, it's public record. Okay. So that's why people will, this is why if you go to my website, it's kind of a joke, but it's why I write so many intellectual property articles about Taylor Swift. People watch her trademark filings like a hawk, because the minute they file an application, then it sets off alarm bells to people watching, like, oh, they're creating something. And she's just an easy example of that. So there's that element where, from a strategic perspective, and kind of taking your question a little bit into a different realm, when I'm working as an outside general counsel or outside intellectual property counsel for somebody, I'm looking at that whole picture. I'm not just looking at how we're going to file a trademark application, because that's just one facet. We're looking at the whole picture, and I'm deciding when we're going to file that trademark application, what's the last minute that we can file it that's also early enough that isn't going to ruin the surprise per se, or signal to our competitors what we're doing. At the same time, anytime I have ever started any company, I file my own trademark applications 2 to 3 years in advance of whatever I'm doing. I premeditate that far in advance. And it's very case by case in terms of the actual privacy concerns. But I did have one client recently who launched something huge, and her competitors kind of were sniffing around. They thought she was up to something. So we waited until the last minute to file that 1B application before she actually started sharing this kind of.
That makes complete sense. In the same realm of A-listers, I believe Tiger Woods did that recently with Sunday Red. Like we found out about his filing like a week or two maybe before they even had their product launch and all of that.
Yeah, I can get, if it's not obvious, I can get so nerdy about talking about the strategic side of like that marriage of business and legal like that. And you can get so very strategic with how you handle the intellectual property and really generate. I mean, I can help people generate the value of their company just based on some of the marketing buzz and some of the investors that we can bring in who get excited once they see the splash of those registrations, et cetera. So it's an all-encompassing endeavor.
Well, switching into AI. So starting off maybe with an easier question that has a broad answer. How do you see AI impacting intellectual property as it relates to creative work?
Good.
For everyone else listening, AI is such a broad term. It's the essential, or like it's the equivalent of saying food. Like there's so many things underneath it. So.
Right. So my honest answer to that is that I think that AI is going to be the thing that changes our copyright laws and trademark laws as they stand today. I don't think that we will have, there's one case in particular that we're watching that I think will be the first one in front of the Supreme Court that I think will decide a lot of this. The New York Times sued. Yeah. It's fascinating if you actually, it's even if you're not a lawyer, it's fascinating to read. But I don't think that our current copyright and trademark laws are suitable for, they can't answer some of these questions that AI has posed. And I can give you an example of what I'm talking about. I think it's going to be similar to the .com boom, obviously it'll be bigger than, but similar to the .com boom of the early 2000s. Most people wouldn't believe this, but I remember when I was in law school, one of the days in our contract class, we discussed the legality of electronic signatures and different forms of a click wrap signature versus just all the different types of electronic signatures. And it was a new area of contract law, which is like kind of hilarious to think about now, but like the law just figured that out not too long ago.
No, that's a great example because I lived through that.
Yeah. It's just kind of, it's eye-opening that a lot of those like electronic signatures were kind of a dicey topic until the
law adapts to the changes in the.
Exactly. So just to kind of very briefly, and you can just tell me to hush up anytime here, but the reason why I don't think that copyright laws currently are the reason why I think that the Copyright Office and the Copyright Office has said the same thing, they're going to have to revise laws, is because in order to own the registration to a work, you have to be the author of the work. The Copyright Office initially came out and said only humans could be the author of a work. So if only a human can be the author of a work, and if only an author of a work can own a piece of intellectual property, then anything that's created with AI, theoretically, again, if we're talking with a very broad stroke,
isn't copyrighted,
can't own the registration to that copyright. under US laws, if you don't own the registration to the copyright before an infringement occurs, you don't have the same rights against that infringer. So that means that theoretically anything created by AI you could never own and anybody could take at any time. So that when we use when I use the words Wild West, I'm not like I'm not just saying that generically. That's like, I mean, it's literally going to be an intellectual property shootout.
Yeah.
So that's where we were at the beginning of the year, and more laws have come out, more cases have come out since then. The Copyright Office has opened up a public notice hearing or notice of a public hearing to determine some of these elements, because obviously that's not going to be attainable. And then that also leads into the question of what is AI? Like, that's a whole other topic, because a good lawyer can argue, like, is a Grammarly AI? Is a preset in Lightroom AI? Like, yeah, I mean, it can be a very slippery slope, obviously. But also most importantly, where the New York Times is coming from is money's not necessarily what that law, it's not what that lawsuit's about. But under current US law, if you can prove a willful violation and a few other factors of your registered copyright rights, damages per incident of copying can range up to $150,000 per incident. So the New York Times, I mean, we're already looking at, I'm not going to do the math. That's why I went to law school, so I don't have to do the math. Let's just say that that'd be $1 billion lawsuit. Like, because ChatGPT can scrape from anything and everything.
Public source. Yeah.
And this is something that the Authors Guild obviously is up in arms about as well, because it can pull from any registered, books or registered copyrights, et cetera. So it's a quagmire right now. And I can get into more detail about what I'm actually telling my clients right now, but I'll stop there.
Add to that quagmire?
Yeah, please.
I think that's probably why media platforms are also installing transcription services. Because if you notice, Apple Podcasts just recently updated their services and their terms to include automatic transcription unless you opt out, I believe.
Mm-hmm.
And so just thinking ahead, more data, more information to use.
Yeah. There's a lot a lot behind the scenes when it comes to, another area where we're going to run into problems. I think a lot of those types, where I think that this is just one element to this larger conversation, but people aren't really talking about, but we're also seeing a huge rise at the same time in privacy laws and accessibility laws. That's going to create a juggernaut of an issue with what information has to be made available to the public that then could be scraped by OpenAI, if that makes sense. So at the same time that we are required to maybe have different transcriptions or make, with different disability laws, make parts of our websites more accessible, we're just opening the door to OpenAI being able to scrape more from more places, essentially. That's a very oversimplified version of saying that. For all of that being said, I want to be very clear. I use AI every single day, and I am not sitting here saying, be so scared of it that you don't use it. I'm saying, hear me well, be smarter than the sheep that you are watching. Just follow.
Don't be enamored by it. Use it.
Yeah, exactly. Just, if going back to what I was saying a minute ago, if only humans can be authors, which there have been a few distinctions to that law since in the last couple of weeks. But if only humans can be authors and only authors can hold registrations to works, make sure that however you're using AI, you're using it in a way that moves the needle in your business and actually helps you be more efficient and effective, but does not create the final product, does not create the final asset that you are creating, putting out into the world that you're claiming intellectual property ownership over. Put your own touch on it. Put your own spin on it in whatever way that may be.
So connected to this, because we will be flooded with artificially created content. I mean, it's already starting. So my question from your point of view, are there markers that can be used to differentiate value? I think there's twofold. One, we know that there's modified food, which is why we have the organic labels and all the other labels that come through the FDA. Do you think that there will be something similar for then creations or content, anything in that realm? And then are there there's been conversation about authenticity and trust and different things of that, how those will rise because of all of the information that's out there that people won't know how to sort through.
Yeah, exactly. Okay, a couple things to say.
That was a lot.
No, I did an AI. It's interesting because I did an AI a legality masterclass last week, and a few new laws have already come out since then. But one stat, I'm going to botch the stat, so no one cite me on this specifically.
We'll look it up after.
Yeah, in the last year, the search for AI, using AI responsibly or AI in responsibility, increased by, I think it was like 4,900%. So obviously, this is something the question you asked is something everybody's asking. All of the labels, and using the example of food, I think is actually a good designation of organic and non-GM, like all of those types of labels. Right. A good example or good corollary here. Each of those labels is the is the byproduct of a lawsuit. So it's going to take this getting sorted out in the legal system, the way that our legal system works. It's going to take case precedents being set. So right now we won't have answers to that for a little while. In the last week, and it does not go into effect, if I remember correctly, until for a couple weeks from now. But the European Union just put out an AI Act. And I think I think that's what most of the world's going to model itself after. It's similar to how they created the GDPR in 2018. And then the world basically uses their own iteration of the GDPR. And they have classified different, and since you read it, you understand what I'm saying, but different types of the use of AI into four different categories of risk. And I think that that's probably the type of standard that's going to be adopted worldwide. You might have seen at the end of 2023, Biden released an executive order stating that, and it was misquoted significally. So I want to be very clear about what this executive order stated. Anything created by a government agency has to include a watermark showing that anything created by a government agency through the use of AI has to include a watermark showing that it was created by AI. That only applies to government agencies. It was a great flag in the ground, but it left more legal questions than it answered. Because it didn't address percentages, et cetera. But I do think so where we're at right now, we don't have legal answers. We can make a very educated guess in terms of looking at what the executive branch of the government's doing and what Europe is doing. But in terms of how that's actually going to impact us as business owners right now, we're going to need a Supreme Court. This is where, if we go back to our government classes back in elementary school, this is where we're going to need the Supreme Court to step in and and make some decisions, and then we're going to have district courts fall into place and make decisions based off of whatever SCOTUS sets out. Right now, though, as business owners, so I put my lawyer hat on, and my answer is, let's be careful and let's make sure that what you're creating you can still own. But I put my business hat on and I say, this is an opportunity for us. This is a huge opportunity for business owners who are pragmatic and discerning with how they handle AI right now. Go off to the races and create, again, use it to be as effective and as efficient as humanly, well, no pun intended, as humanly possible. The intellectual property that you're creating, as long as you are still the creator of that intellectual property, is going to become more valuable because it's going to be more rare that somebody actually can register the intellectual property. So right now, people who are being smart and are making sure that the assets that they're creating are created enough by a human in addition to AI can actually obtain those registrations. And it's going to be later on, when you're kind of bringing this conversation back to our first topic, but later on when you're in a position where you might want to sell the business, or you have somebody who might want to invest in the business, et cetera, you now have a golden nugget of an intellectual property asset that can be so much more valuable, because you actually have the registration. And again, I think it's going to become more and more rare that people follow the right protocols to actually be able to obtain those registrations.
As part of that, would you then be documenting the prompts that you use in the creation process?
No.
Okay.
No, that's not, what I would be doing is, because right now there is a big, like, I have my own personal argument in terms of inputs and outputs. But the law we don't have any legal standard. That's a huge facet of the New York Times article, and a huge facet of OpenAI and Microsoft's response to that lawsuit. But right now we don't have any guidance in terms of inputs and outputs. I mean, if anybody's used anything like ChatGPT, you know that unless you know what you're doing, you're kind of
right. That's why I was curious if prompts.
Yeah, it's not necessarily like you're not necessarily saving yourself time. But what I'm making sure is that whatever I produce at the end of the day, I would be able to create and then I have to do this anyways when I'm helping somebody sell a piece or license out a piece of intellectual property. I'm looking at how I would create the value, literally looking at an online course, for example. Let's just be generic and say it's 30% text, 30% audio, 30% video. When I file a copyright, I file a copyright for those three elements together. And so if somebody used AI to help generate, let's say, half of the text portion of the course, then generally speaking, let's just say they used it for half of the text, that'd be about 15% of the overall. And I'm getting dangerously close to doing math here, but that's where we'd be able to say that the user or that the creator of that course only used approximately 15% of the overall was created by AI.
That makes sense, because then they retain still majority in ownership.
What I'm saying is don't use ChatGPT and then just put it up on the internet.
Right.
That freaks me out for a lot of reasons. And a lot of lawyers have gotten in trouble for doing that because of all the missings or ChatGPT just makes up some stuff sometimes.
Right.
So, yeah.
One of the things that you said about being discerning in use, and I think that's really important right now for early movers and first movers, is data portability and where you decide to start. So my question first starts off with, how will the convenience of using these tools become a long-term crutch if people don't consider data portability, the cost to switch platforms, and how these platforms, whatever they choose to use, how through network effects, et cetera, it will become more sticky because the tool will become more customized to the content, and it's that cycle that feeds itself. There was a quote actually that I pulled from the EU Act and the Future of Life Institute, who had that article about the first mover advantage of currently leading GPAI models, GPT-4, Gemini, Llama 2, allowing them to enjoy the network effects with the customer lock-in, and then switching costs will act as a barrier to entry for SMEs and startups. So sharing that in context of my question.
Yeah, this is where, again, we're at a place where we don't have that much legal guidance in terms of how much AI we actually can use and still own what we create.
Right.
So I say that as a just before diving into actually answering your question, because I want everybody listening to maintain a level. This is maybe a little Pollyannish of me, but I want everybody listening to be able to use AI, but be in a position where you're still independent of AI. So it's not critical in the same way that you're building your business so that your business doesn't rely just upon you.
Right.
It's the same concept as build a business to be sellable. Now we're looking at AI as just another component to that. I am building my business and I'm utilizing AI in a way that enhances it today. If ChatGPT got shut down tomorrow, I'd be fine.
Right.
I would miss it. I would miss certain elements, but I can operate independently of it. And that's that's my kind of like broad answer to that. Is just we want to, and that applies to more than just AI. Anybody that you hire, you never want to be solely dependent on. Yeah, you never want to be solely dependent on that one. What's the term, like white elephant or whatever
Right.
it is. We have to be more dynamic, and we have to be more visionary than that, and we have to be more strategic than that.
Spread your risk.
Exactly. And that's earlier when I kind of jokingly said, except for I'm not joking at all, a leader, like we have to think of ourselves as the leader of our company, and a leader has to be prepared for chaos at any time. That's arguably one of the definitions of leadership. Be prepared for chaos at any time, and be able to calmly and in a commanding way lead your team through that scenario. So that means we don't want rose-colored glasses thinking that AI is going to always exist in the way, especially in the accessible way that it is now. Another, just a quick note, not to like stress everybody else out. But something I've been thinking about a lot lately in terms of this conversation as well is just the rise of hacking and I mean, we are so reliant upon, I've been thinking about that more this year than ever, because my entire Meta account was shut down this last year. I lost everything from 7 years that was on any social media platform. And it's a very eerie, even though, you have your email list, you have your, all
Right.
that you do things, it's still an eerie feeling to realize just how much you get.
Almost like a chunk of your life has been erased.
Yes. And how reliant you become, even when, like, literally it's my job to think farther than that.
Right.
It was a little bit of a culture. It was a little bit of a shock to my system to realize I've built a digital law firm. And how do we, what happens? Like the IMF is literally examining the issue right now of if there was essentially a pandemic of like a cyber pandemic. Those are the types of,
I think.
Yeah, those are the types of it all. I don't want to just say that and drop that bomb and then stress everyone out and then not address
and
it.
then just leave like, hey,
yeah. And on that note, No, but I say that because your point is a valid one. It's just one element of what we need to be thinking of as business owners. We need to think more like dynamic and more look at it like look at the whole truth.
No, that makes sense. And I think, again, like I liked seeing that question about locking customers, like being discerning about like where you choose to build a station, we'll say, not a home, because data portability is still an issue. Like you said, with Meta and like any other platform, there's so much tied to it. Like even LinkedIn, you have a lot of contacts and you can't export any of that contact information, at least that I've found. And
Oh,
so, I
and
mean,
it, yeah, sorry, I didn't.
and people build livelihoods on these platforms. And
And then
so
people
there's
market it.
no accountability because
Yeah.
the service isn't there. That's not their goal.
It's a privilege, not a right. That's what people
Right.
don't understand. And that's what's really, one of the things, just not to, not that you hit a nerve or anything.
No, that's a great point. That's
So
why I'm
many,
glad you said it.
yeah, I hear so many people in the entrepreneurial space talk about you build your email list, you own your list. And well, yeah, I'm sitting here as somebody whose Meta account was wiped out. So I will absolutely endorse the fact that like have an email list. You don't own your email list. That's not true. That's never been true. And it will not be true. If your ConvertKit account gets shut down tomorrow, you cannot send a subpoena to ConvertKit to get your email list. That's how I define whether or not you own something. I don't
I
know how
believe
to
that.
make that more simplistic,
That makes-
but yeah.
Anything else that small businesses should know about AI? I feel like we've barely touched it, but you've shared a wealth of information for people to chew on and for them to research.
I two again kind of um broad I guess broad notes that I would mention right now. One goes back to what you were talking about earlier with the increased rise in people looking at researching how to use AI responsibly and just those types of questions. I think that we're going to see, I think some of the case law that's going to be set first are cases against deep fakes. That's a huge issue.
Yeah.
I get a little bit nervous. Oh no, more than a little bit nervous. I've sent some private messages to some of my friends and colleagues when I see them use AI and like use the celebrities, like create images that use celebrities or something like that. And that's a whole other 30-minute conversation about copyright laws, but I would just tread lightly because in terms of using somebody else's name or likeness
Always.
in that way, exactly. It's a good practice in general. It's something that's going to be, I think, very critically examined, we can say, in the next couple of years. And then the other thing that I would say is that I'm telling every single one of my clients, because again, going back to the question of responsibility, your clients are going to start asking you about how much of what you're creating is created with AI, and they're going to just start to have more questions.
Yeah.
So premeditate that that's going to happen. I'm recommending to everybody that in your terms and conditions on your website, you have an AI disclaimer that essentially just states that, or at least the way that I've written mine, it states that you've reserved the right to use AI. And the critical part is if you want to, and the critical part is that you also reserve all of your intellectual property rights to what you are creating, regardless of the amount of AI that you are using or that you have used to create whatever's on your website, and that the creation of your website is still considered to be wholly human. And that goes back to what I was talking about a minute ago with only authors can be humans, et cetera, et cetera. So add a disclaimer to your terms and conditions and then your client agreements as well. I think it's important I think it's a business decision on whether or not you want to actually add a line into your agreement that states that you have to provide a disclosure or a disclaimer to your client if you use AI. I think that that's a little bit aggressive personally. I don't think that I don't think that's necessarily something that you have to do, but I do think that it's important within your client contract that you specify that, depending on whatever type of business you have,
Right.
like no more than 50% of the work created will be used with AI, whatever that might be.
I think that's good because I think that also reinforces the value that they're paying for too, depending
Exactly.
on the field or the industry.
I've already seen, exactly. I've already seen it. I work with a lot of wedding professionals, and I've already seen people try to get refunds after work has been created and that happens with any in the wedding industry. People are just looking for a way to get a
Yeah,
refund.
cheapen the.
Exactly. And so photographers are one class of service provider I'm talking about. Like, I think it's really wise for a photographer to specify, like, I think it's completely fine for a photographer to use AI to like Photoshop. And that's why I
Right.
used the example of a preset earlier, like smooth out lines, maybe delete somebody sneezing in the background of a,
I
family
think the
portrait.
transparency and communication there, it's all about just
Yeah,
setting the expectation for the client so that they don't have questions and you're preserving the value of what they're spending.
exactly.
That's
It's all
perceived,
about,
but still.
yeah. Well, exactly. A contract is a meeting of the minds. And so we don't want to create a scenario where your client can say, oh, I had no idea you were using AI. That's not, to your point, I never would have paid that amount for somebody to use a robot to do part of the
Right.
work.
Yeah.
It would say. So anyways, that's my last tidbit of.
Perfect. No, I love that. I've loved our conversation. Thank you so much for being here, Paige, and we look forward to talking to you soon.
Absolutely. Thank you so much for having me.